Let's look a little more carefully at damages. Let's talk about, first of all, the classification of damages. Damages can be classified in different ways. Now, all of the damages we're talking about now are monetary damages, meaning money damages. These are also known as non-performance damages. We discussed a number of performance remedies, performance damages yesterday, things like specific performance. But today we're looking solely at monetary damages, money damages that are required to be paid. There are three components to monetary damages. And those are, first of all, compensatory damages, incidental damages, and finally, consequential damages. Now, you should have been introduced to the differences between those types of damages in your introductory legal studies course, but to go into them in more detail, we'll give you a little refresher. We start with the notion of compensatory damages. Now, compensatory damages, as you might expect from the name, are designed to compensate the aggrieved party for the injuries that were actually sustained. So the compensatory damages are to make up for the loss of the benefit. Whatever the benefit was to be gained from the contract, the compensatory damages are going to make up for that. So if a seller fails to deliver conforming goods, and the buyer is then unable to purchase substitute goods, the buyer can claim damages in the amount between what they would have paid under the contract and what they eventually had to pay for substitute goods. Similarly, if the buyer fails to take delivery or to pay for the goods, and the seller is able to resell the goods, then the seller can claim damages if the resale price was less than the contract price. So the difference between contract price and mitigation price, and I say mitigation because that will cover both the purchase of substitute goods, which we call cover, and the resale of goods, which we call resale. So the difference between contract price and mitigation price is the compensatory damage figure. Incidental damages. Now, incidental damages are a second classification of damages, and incidental damages are the expenses caused directly by the breach. So incidental damages are those that flow directly from the breach. For instance, if you are a seller and you are going to deliver bicycle frames to a manufacturer, and the manufacturer then notifies you as the seller that it will not take delivery of those frames, well, the compensatory damages are going to be composed of how much it takes to, what the difference between the resale price and the contract price. But say that you as a seller, you've had to put those frames into a warehouse. That's cost you money. There's a storage fee attached to that warehouse. Well, that storage fee is what we call incidental damages. They are damages that are caused by the breach, but they are not the benefit of the bargain. They are not what the contract was actually about. You might look at incidental damages as those damages that occur as a result of mitigation. Similarly, if a buyer is unable to purchase goods because a seller breached, the buyer is going to have to mitigate by purchasing substitute goods. Well, that purchase of substitute goods is going to have a cost as well. There's going to be time and money and energy involved in finding those substitute goods, and the difference between what they would have had to pay and what they did wind up paying, that's the incidental damage. So think of incidental damages as the costs of mitigation. And finally, we have consequential damages. Consequential damages are damages that flow indirectly from the breach. They arise as a foreseeable consequence of the breach. However, they are not directly caused by the breach. Now, in a commercial setting, consequential damages tend to be loss of profit. What was the loss of profit? Consequential damages you may look at it in the sense of you've arranged to buy office furniture from a company. The buyer has arranged to purchase office furniture from a seller. The buyer is going to open for business on October 1st, and the seller has promised delivery of the furniture by September 15. Well, say September 15 comes and goes with no delivery of furniture, and instead the furniture is not delivered until the middle of October, October 15th. Now, the purchaser, the buyer, has lost all of the profit that it would have made for that business because it was unable to open the business without the furniture involved. So we missed at least 2 weeks of sales as a result of the breach of contract. So that loss of profit, is what we look at as consequential damage. It is damage that flowed from the breach but was not caused directly by the breach. It was an indirect form of damage. Now, consequential damages are limited. They're limited by the concept of foreseeability, meaning any result of a breach of contract is not necessarily recoverable. If in fact, in our opening hypothetical, if the furniture was not delivered on time, and then the owner of the business was so distressed by the late delivery that the owner suffered a heart attack and then incurred a 6-month hospital stay as a result of the heart attack, well, one could argue that the heart attack would not have occurred but for the breach of contract. However, from a perspective of recovery, that party does not get to recover the cost of the hospital stay. Why? Because that was not foreseeable at the time of the contract. Now, loss of profit probably was. They knew that the business was going to open on October 1st. They failed to deliver the goods, the furniture in time. Therefore, they probably anticipated that there may be loss of profit recoverable. However, the extended hospital stay would not be foreseeable. So the CISG limits the concept of consequential damages, and it does so by imposing a concept of foreseeability. Now, foreseeability, how do we determine whether something is foreseeable or not? Well, under the CISG, it is both an objective and a subjective test. Meaning, on the one hand, we look at, well, would a reasonable person in that same or similar position have foreseen the result or foreseen what would happen if a breach occurred? That's an objective test. But there's also a subjective element as to what did this particular person involved in the transaction, what did it foresee? Was it reasonable for this person to have not foreseen it based on the particular knowledge or skills of that person? So that's consequential damages. Consequential damages are limited by the concept of foreseeability, and foreseeability is determined by both subjective and objective elements. Now, a common form of consequential damages, another common form, is interest. Interest that's required to be paid. If a party fails to pay the price, the other party is entitled to interest on that money. So if a buyer fails to pay a purchaser for goods after having taken delivery, and the buyer fails to pay on a timely basis and does not wind up paying until 6 months later, that seller is entitled to recover interest on that sum for the length of time that it otherwise would have had the money. And again, this fits within the scheme of expectation interest. Where would the parties have been had the breach never occurred? We'll talk a little bit about calculation. Now, in the past, I've had students actually do the calculations for damages, but many struggled with the math involved, and therefore, for this lecture, I'm just going to talk about what the principle is behind it. Now, the principle of damage calculations is the notion that is based on the notion that the parties can determine what their potential exposure is prior to a breach of contract. The parties can know with a certain degree of certainty that what the damages will cost them. So CISG Article 74 reflects a general principle, and the general principle is full compensation, which is to say that an aggrieved party is entitled to receive a sum that will put that party back in the same position as they would have been in, except for the breach. The aggrieved party, the non-breaching party, is entitled to monetary damages, non-performance damages, in amount to make that party whole. What we want to do is we want to make the party whole based on their expectation interest. So that compensation is going to be measured by the difference between the value to the aggrieved party of the performance that should have been received and the value to that party of what, if anything, actually was received. So in general, we're going to look at the calculation of damages to be compensatory damages, which is to say the benefit of the bargain, plus any incidental damages, plus reasonably foreseeable consequential damages. Because all of those three elements are necessary in order to make a party whole. Compensatory damages plus incidental damages plus reasonably foreseeable consequential damages. Now, all of that theory, however, is subject to the duty to mitigate. And I mentioned this before, that the CISG requires a party to minimize her losses after a breach. Now, this CISG article, or CISG provision, is found in Article 77, contains the duty to mitigate. And it says that a party who relies on a breach of contract has to take reasonable measures to minimize their loss, to mitigate their loss, especially loss of profit. If the party fails to mitigate, unreasonably fails to mitigate, then his damages may actually be reduced by the amount that they could have mitigated, that they could have. And remember, mitigation for a buyer is called cover, and that's the purchase of substitute goods. Mitigation for a seller is called resale, and that means reselling the goods to another buyer. Well, if a court determines that, for instance, a seller failed to resell the goods to another buyer, the court can subtract from that damage figure whatever amount the seller would have received from the sale of those goods. So our compensation is going to be based on the notion of contract price minus, not the actual price because there was no actual resale, but what they could have sold for. So contract price minus a reasonable resale value. Now, how does a court determine what's reasonable? Well, they can base this on the notion of market price. What is the market price for the goods at the time the aggrieved party could have resold them. So in essence, what happens is the party who has been aggrieved by a breach cannot simply rely on the breach in order to recover damages. That party must go out and attempt to mitigate its damages.